Good evening, everyone, and welcome to our live Q&A session tonight. We are joined by recent graduates and international students from institutions all over Canada and, of course, internationally as well. My name is Han, and I will be moderating your session tonight. Let's go to the next slide. These sessions are brought to you by Devant. Our company name, Devant, is in French, quite literally means in front of. We believe that our services and support will bring you in front of the rest of your journey to stay, work, and succeed in Canada. Devant is an organization tailored specifically to cater to international students with the expertise over 60 years of combined experience working in higher education and career development. First, I have a few housekeeping items to go over with you. These are just a few administrative and logistic topics to make sure that everything goes smoothly tonight. All participants have been muted. You should be able to hear via your computer device, and there's no need to use video. The session is currently being recorded, and if you have questions, please use the Q&A section at the very bottom to ask questions. Future workshops, please go to the events tab on the Devant platform website as you see in front of you. Please welcome to all of those future sessions. Again, my name is Han and I'll be moderating tonight, but I'd like to introduce to you our guest speaker. Elizabeth Long is a leading immigration lawyer, an active advocate in immigrant and refugee rights in Canada, and frequently presents and advises on immigration issues to universities, members of parliament, and the media. She holds a Juris Doctor Law degree from the University of Toronto and a Bachelor of Arts degree with honors in psychology from Memorial University of Newfoundland. She also holds a Master of Law degree from Osgoode Hall Law School, York University, where she focused on the intersection between immigration and labor and employment law for foreign workers. She's been certified by the Law Society of Ontario as a specialist in citizenship and immigration law, which is a prestigious list of which only approximately 65 lawyers in Canada belong. Welcome, Elizabeth.
Thank you so much. It's great to be here, guys. Okay, so let me just make sure I can share my screen here. Okay, here we go. All right. So today, our main topic is going to be talking about how to speak to your employers to have them support your immigration applications. But before we do, I always like to go through some basics of things that you guys need to know while you are international students and attending school. So the first thing is extending your status. One of the main things you need to understand when you have temporary status, it's an international student, or if you have a work permit as well, is that if you apply before your current status ends and you apply to extend it inside Canada, you have what it's called implied status or maintained status, in that you can continue on. If you apply to get a study permit, you can continue to study. Or if you apply for a work permit, you can work while waiting for the decision to be made, okay? But you only get implied status if you apply properly. Now, if you forget to apply beforehand, you have a second chance called the restoration of status. You apply within 90 days of losing your temporary status. But when you are applying for restoration of status, before you actually have the new application approved, during that time, you can't actually do anything. You can't study, you can't work until you actually get the new study permit or work permit issued. So the first thing you want to do, make sure you have that date of when your status ends clearly on your calendar. Give yourself 3 reminders and know exactly when that ends. Let's talk about studying and working on your study permit. One of the main things is you need to actively pursue your studies. That means you are attending classes, you're going to the exams. Otherwise, you will lose your status within 90 days of not being a fully enrolled student. There are two exceptions to the rule: the scheduled breaks, which is on the academic calendar. Everyone has those breaks. That's okay. And also authorized leave. Authorized leave is when you as an individual go to the school and seek permission for them to give up to 150 days. So basically 1 semester off because of some personal reasons. Now you have to get the school to give you that permission before you actually take the leave. And the authorized leave is only good for 150 days. If it's longer than 150 days, then you should apply to restore your status as for a study permit, or extend it perhaps as a visitor as well. Okay. Working while you are studying. Now, you can only work when you are a full-time student, not a part-time student, not if you're on authorized leave. And when you've completed your program, you cannot work based on your study permit. Okay. The only exception to that rule is if you have completed one program and you're going to start a new program within 150 days and you've already been accepted to that new program. So for example, if I've completed my first program in April, I'm going to start a new program in September. As long as I've already been accepted to the new program, I can work during that semester in between those summer holidays. Okay. All right, let's talk about the post-grad work permit. First of all, you need to see whether or not you should apply for the post-grad work permit, especially if you're doing a program of less than 2 years, or if you're doing, 2 1+1 programs that could also equals to 2 years, because with that, you get the 3-year work permit. But if you only did a 1-year work program, you will only be entitled to a 1-year post-grad work permit, except if you have a master's or PhD. Okay. Now, some of the things that you have to keep in mind is, can you get permanent residence while you are on that work permit? Are there ways to extend your work permit, etc.? And you should really seek proper legal advice before you even apply for a post-grad work permit in most circumstances. Sometimes I have people who complete their undergrad, for example, and then they're going to go on to do their master's, and they apply for post-grad work permit just because they can. In that case, they could be really wasting their post-grad work permit, and by the time they complete their master's, they will probably only have a very short time left on their post-grad work permit. Remember, you can only qualify for 1 post-grad work permit in your lifetime, so you really do need to make it count. One of the very important things that you need to keep in mind is distance education. That is supposed to be less than 50% of your program. Okay, so make sure that, there were some COVID rules before during COVID, and now the government is really switching back to the regular rules. So especially if you are starting your program now, just make sure that your distance education is less than 50% of your program. Full-time student status is very important as well for every semester that you do, except in the last semester. Sometimes people will say, well, you know what, I was going to fail this course, so I dropped it. That could be an issue if that takes you down to part-time student status on your transcripts. Okay. For me, I would rather someone fail a course and still have showing that they've done like 5 courses during the semester than be down to a part-time studies because they dropped classes, because that will wreak havoc with regard to your ability to get a post-grad work permit in the end. Okay, so we're going to be talking about when you should apply for your post-grad work permit. Now, the IRCC tells you you can apply for your post-grad work permit within 180 days of completing your studies. But I'm going to tell you to apply. Your deadline that you keep in your mind should be 90 days from the time that you've completed your studies or when your study permit has expired. That is because you are supposed to apply when you have student status, and you lose your student status when 90 days after you completed your studies. Okay, so it can be very much more complicated if you apply after the 90 days. You should apply for restoration of status, for study permit, etc. It can be quite complicated, and you won't be able to work while waiting for your work permit. So keep it in mind. Apply the earliest of when your study permit expires, or within 90 days of you completing your program. Completing your program means the first time you receive any sort of correspondence from the school that you have completed your program, whether it's your transcripts or a note on the portal or something, okay? Not just, for example, when you get your degree or convocate, okay? The first time you receive notice that you've completed your program, start there, count 90 days, or if your study permit expires earlier, the due date is your study permit, okay? If you do that, then you can start working while waiting for your work permit to be issued. Okay, so just wanted to go over a quick timeline for when you can work at the end of your program. Let's say you're writing your final exams. You're still a full-time student then, okay? So you can continue to work. If you're waiting for results, if you're a full-time student, you're still a full-time student, so you can continue to work. The school has notified you that your program has been completed. Okay, at that point, you are no longer considered to be a student by IRCC. Therefore, you have to stop working. But you can start working again when you submit your postgrad work permit application within 90 days of completing your program and while your study permit is still valid. All right, now let's get to the parts that is specific for today. The topic that I wanted to speak with you guys about is how to speak with your employer when you need them to support your immigration applications. You know, these days, the scores for the express entry draws are extraordinarily high, higher than they have ever been before. And oftentimes, even if you have been working in Canada and you've completed your program in Canada, it may not be enough to get you invited to apply. Oftentimes, you may need to get a employer-specific work permit or LMIA to get you arranged employment points for express entry to boost your points. Or you may need to apply for an employer-specific provincial nominee program where you need their support to help you, okay? And oftentimes employers, they may be reluctant to do so. Maybe they have heard a lot of rumors about, you know, how difficult it is, and, you know, or they may think that they are under certain obligations, or they may think that there's a lot of work involved. All of these may be true or false, depending on the circumstances. So let's get into it. First of all, what does employer sponsorship mean? Most employers that, you know, I speak to, they say, I don't want to sponsor anyone. Okay, well, what exactly does employer sponsorship mean? It means nothing in Canadian immigration law. There is no such thing as employer sponsorship. If someone tells me, oh, I don't want to sponsor the person, it means that A, they don't know what they're talking about, or B, they don't want to be under some sort of obligations that they think that they would be under, okay? The employer sponsorship is a US term. It has no basis in Canadian immigration law. So, but it's a very loaded term because it makes people think when they're sponsoring someone that they have certain obligations. So when you want to speak with an employer, do not use the sponsorship term. Be very specific on what you want them to do. There are certain ways that I say employers can support your permanent residence or your work permit. Okay. And so you need to understand what exactly they need to do and make sure you have that terminology right. Let's first talk about the LMIA, the Labor Market Impact Assessment. You know, I represent a lot of employers, and you know, oftentimes they'll have employees coming to them and say, oh, they want me to do an LMIA. What does that mean? I don't want to do it. Do I need to do this? You need to understand that this is an employer application. This is not your application. It might be there to support you. And, you know, you need an LMIA sometimes to get a work permit, but this is an application that the employer applies. You have no part in submitting any documents or information to the officer. This is an application that the employer signs off on. Okay. And they do have to do a lot for this application. They have to advertise and show that they cannot find another person in Canada to do the job. The government recently made some announcements where they want to curb temporary foreign workers in Canada. And what they have done is try to make it harder for employers to get LMIAs. One of the things that they have said is that they need to try to recruit not only Canadians and permanent residents, but also those who have authorization to work under open work permits as well. And then, or sometimes there's another kind of LMIA called the Global Talent Stream for STEM workers, where instead of recruiting, they can submit a labor market benefit plan where they promise the government that they're going to hire Canadian workers or provide training to Canadian workers, etc. Both of these have certain obligations, have quite a lot of work in many cases for the HRs and the employers to do. Okay, and they may or may not apply to you. For example, if you are working in a position where there are many Canadians with your background who could do the job, then even if the employer moves forward with the LMIA, their application could very well be denied. Another one is the salary. For LMIAs, your salary needs to meet the median wage of the occupation. Or if we're doing global talent stream, higher even for a lot of occupations. And so it could be that if your salary is far below the median wage, that the employer is just not able on a business standpoint to raise your salary to that point where an LMIA is possible. Okay. So when you're talking to the employer, do not demand that the employer does this. Okay, because it is a lot of obligation on the employer. Normally, if I am working with a client, I can sort of assess as to whether or not the LMIA is viable for their position. And then if it is that it's not, it is viable, and if it is that it is the only way that a person can continue to get a work permit, then it's very important that I speak with the employer, that they understand exactly what they need to do and their obligations as well, because there are audits as well. If they say that they're going to, hire you with a certain salary, they may need to raise the salary to meet the median wage afterwards if the median wage rises. There are a lot of obligations involved with the LMIA, and they have to be comfortable with that. A lot of times employers, if they are not explained as to what they need to do, they'll get frustrated and they may quit halfway through, or they may delay the applications, or they just won't produce the documentation that they need to do. So it's very important that the employer goes in with their eyes wide open, and it is possible for the LMIA to go through. The International Mobility Work Permit program work permits are also employer-specific work permits. So with the LMIA, you have an LMIA, you can extend your work permit. You can also get your arranged employment points. Most of the time, it'll be 50 points added to your express entry score as soon as you get your LMIA. And some of the LMIs, you need the work permit based on the LMIA. As soon as you get it, you get the 50 points. With the employer-specific work permits, other than the LMIAs, and these are under the IMP program, you will not only need to have that work permit, but you will have to have worked with the employer for at least a year in order to get the arranged employment points, okay? And so some of the ways we can get these work permits, these are LMIA exempt. So the employer does not need to go and make an LMIA application in order for you to get the work permit, okay? There are certain categories that we often use for students. For example, if you're a national of certain countries, Mexico, Peru, Colombia, US, EU, UK, Australia, Japan, Chile. So there's a whole list of countries, and depending on the free trade agreement, depending on your job, you may be able to get a work permit because you're a national of that country. If you're a French speaker, we can get a Francophone work permit for you. There's also programs for certain, younger people, usually under the age of 30, or in some countries 35, depending on the countries. There are certain countries that you can get what's called the International Experience Class work permits. And one of the ones, the working holiday, which is the open work permit, tends to fill up quite fast. And the working holiday work permit will not give you 50 points. But the young professionals, which is something where you have to have a job offer, will get you 50 points. Okay, so those are some of the programs that we often can apply for you. Now, if you're lucky enough to be able to apply under the the IMP, you still have to have the employer support your application. What do they need to do to support your application? Well, they need to register what's called an offer of employment. So in the offer of employment, they need to key in details of who they are, what kind of work permit, why you qualify for the work permit, and very, very importantly, the duties, your salary, benefits, etc. Okay, and hours. And whatever they key in with regard to your job, they have to adhere to while you are working under that particular work permit. Because 1 out of 4 employers are audited if they register an offer of employment, and they need to provide information to the officers that they have adhered to the terms of the offer of employment. Okay, it's not too much work to register the offer of employment. Oftentimes, we fill in that information for the employer, have them review it. It's done, we submit, and it takes just a few minutes for it to be registered automatically online. Okay, but the main thing is they have an obligation to adhere to the conditions. Under a lot of these programs, there may not be a requirement for you to meet the median salary. Some of the free trade agreements do want to see more or less, and others, it's not specified, okay? But what is registered on the offer of employment is key as to whether you can qualify for the work permit, and also very importantly for the employer afterwards, whether or not they have adhered to that offer of employment. So it's very important that that information, that offer of employment, is reviewed by a lawyer. We work with employers where we represent the employers to help getting the work permit. We also work with individuals where they need that work permit and they ask us to work with the employer. The best scenario in either case is for us to review the offer of employment, for us to draft the support letters, and we create the package that we either submit it online, or you can oftentimes even go to the border to apply for the work permits, okay? But this is an employer-based program. It's much, much simpler for the employer to support you with regard to these work permits. They don't have to recruit Canadians. They don't have to do any of that, okay? The third thing that we often see that we need the employers to help us is for employer-based provincial nomination programs. I'm going to speak in particularly about the OIMP employer-based streams. Now, there are also other programs such as the RNIP programs, the AIP programs. All of these are employer-based permanent residence applications, okay? And so the employer needs to support you. One of the main things, with regard to these programs is do not blindside the employer and submit your profile into the pool. And then after you're invited to apply in Ontario, you only have 14 days to submit your application. Then go to the employer and say, hey, you have to sign this form. Otherwise, I can't get it. And yeah, by the way, yeah, you just have to do it. Employers do not like that. They do not like being cornered, and they certainly don't like it that you didn't discuss this with them. I'll tell you a couple reasons why employers often do not want to support these kind of programs, especially if you back them into a corner. The first thing is the employer, even if they wanted to, they may not meet the qualifying conditions. Okay, so for example, for OIMP, if you're in the Greater Toronto area, the employer has to be in business for 3 years, have 5 full-time Canadian or permanent resident employees, and have a gross income of over $1 million. Now, you might assume that your employer can do that, and maybe a lot of employers can, but even some of the larger employers, if they only have a subsidiary office in Ontario, they might not meet those requirements, okay? So the first thing, we do when we speak with employers to make sure that they meet those conditions. Otherwise, you completely wasted everyone's time if you put yourself into the pool and then turns out they can't even qualify. Second thing, and very importantly, employers, when they apply for these kind of programs, they have to submit information through the forms that they fill out about their businesses, about how much they have as an income, about how many full-time employees they have, and they may need to submit documents about other employees. This, most businesses consider very sensitive information, and they don't necessarily want their employees to have this information, okay? And for many employers, this is one of the key reasons why they don't want to help, especially if you say, okay, you only have, you have to give this to me in a few days, okay? Now, one of the things that lawyers can do is they can create that firewall between you and the employee, you and the employer. So when we submit applications for our clients, we submit everything through our employer portal. The employers provide us with their documentation, and we don't share them with the employees. For you guys, why would you care about what the employer is as long as they qualify, right? For the employer, that creates a certain sense of comfort for many of them in that they know that we are under solicitor-client privilege and obligations not to share information, and we won't share information with you. So they're much more comfortable in doing it that way, where we submit their information and we submit your information and ensure that everything is done correctly. Okay. All right. So I just want to quickly run over next steps for what I would recommend you do if you need the employer to help you. First of all, understand your immigration pathway. You need to understand what exactly works for you. Do you need to have an LMIA? Could you qualify for other kind of work permits? Could you qualify for permanent residence even without your employer support? Know what you need before you actually just talk to your employer. Okay. Now you should talk to your employer about ways to help you because they have a vested interest in keeping you to work for them. Hopefully they like you and hopefully they want you to keep you working for them. And I would be very honest with them in terms of your ability to work long-term with them if you have a work permit that is going to expire. Okay. Honestly, if your work permit is going to expire and you don't have your permanent residence and you don't have a way to extend your work permit, what can you do? You'll have to leave Canada. You'll have to, and before that, you may have to change employers to find an employer who's willing to support you. That is the honest truth. I wouldn't say it in a threatening way per se, but I would say it in a honest way. This is what is going to happen. And more employers are getting it. They, realize that if your work permits are ending, and a lot of people, unlike before, are not able to apply for permanent residence on their own. Once you've spoken to them, offer to arrange a call between your employer and your lawyer. When you have a lawyer who works for you, when we work for an individual, our best interest is the individual's interest. If I represent a company, the company's best interests is what I am working for. And most of the time that will align. Most of the time it will be, we want to extend the work permit for the employee, for the individual, but sometimes it may not align. So it's important oftentimes if you want to do something that you may want to hire the lawyer yourself. In any case though, the lawyer needs to communicate with the employer if you need the employer's help, okay? That is very important. If you want someone's help, you need to tell them exactly what to do and they have to be honest with them, right? We tell the employer exactly what is happening. We give them a chance to provide us with their questions, and we give them a honest rundown of their obligations as well. Finally, you need to retain a lawyer to represent you in these cases. When you need an employer's help, you need someone, first of all, to ensure that there's a proper firewall between the employer, not giving out sensitive information to you as the employee, okay? Also, you need someone to ensure that whatever the employer is doing is done correctly, okay? Because it is an employer-based application. Also, what you're doing is, of course, done correctly, but the employer as well. So you need someone who can ensure both sides are done. Okay. All right. So we are ready for some questions. By the way, this is our contact information. If you want to come to us for a consultation, we always offer Devon students a discount. It's only $100 for a discounted consultation, but please let us know you've come to this webinar and you're coming from Devon. Okay, we also post regularly on social media as well. And we have videos for employers as well, so they can watch to see for example, what is an LMIA? What's the difference between LMIA and IMP programs that might help you as well.
Great resources.
Great.
As always, we have a lot of questions, Elizabeth, for you. So let's start with the first one. Harish, I have pest controller and fumigator license from Ontario government. Am I eligible for certificate of qualification points for the permanent residence?
So I think what this person may be speaking to is express entry. There are certain occupations that you can get professional certification and you get 50 points. I am not certain that these licenses are the trades licenses that will give you the 50 points. I'll have to double check, but I don't believe this qualifies as one of the trades, but I'll have to double check about that.
Thank you very much. And by the way, we always, of course, have Elizabeth's email and contact information should you want to connect with her after the session. Rhoda asks, hi, I will be finishing my co-op at this April 26th, and I have applied for an expedited graduation process, and the latest they can give the completion letter is May 3rd. Given the policy that we can only work more than 20 hours until April 30th, should we stop working on May 1st to 3rd, since I will have rendered my 16 hours on April 29th to 30th? They fall in the same week.
Okay, so the co-op work permit that you have is only good for your work within the co-op program. Even if you wanted to work for the employer afterwards, that doesn't cover it. With regard to your completion letter, so as soon as you've completed your program, it's not even when they issue the completion letter. It's what it says on the completion letter as the date that you've completed, or when you first received notice that you've completed the program. Whichever one it is, that date is when you have to stop working, period. You can't work full-time, you can't work part-time, you have to stop working, period. After that, you can start working once you have applied for your postgrad work.
Right. Okay. Hamza, this is a little bit on the general side.
Yeah, they want to have advice on the provincial nominee programs. There's so many provincial nominee programs, across the country, and there are different programs within the provincial nominee program. So do come for a consultation, and we can certainly see which permanent residence program would work for you.
Right. And another person asks, I have a question about 50% online classes recently update, but I don't know what the question is. I guess it's about the top.
Yeah, so they've gone back to pre-COVID online postgrad work permit qualifications. There's a little bit of an overlap for some people who went into programs beforehand, but now with everybody, just keep in mind, don't go over the 50%, especially if you're starting your program now. I'll have to see what program you're doing in order to see about this 50% online. But in general, as a general rule, if you can go to not the online classes, and you can have a choice to go to class, in-person classes instead of the online.
Okay. Next question. I will graduate in April for my 1-year full-time program. I plan to apply for my 1-year postgraduate work permit as soon as I get my graduation letter and transcript, approximately the 2nd week of May. I have a full-time job offer presently and plan to resume as soon as I send out my postgraduate work application, deemed approval. Question is, what are my options to still legally stay and work in Canada upon the expiration of my postgraduate work permit? Due to the age, I am not qualified for express entry or such PR pathway options.
This person needs to have a consultation with us before they apply for the postgrad work permit. It could very well be that with 1 year of the postgrad work permit, they don't stand a chance to get permanent residence. I don't exactly know what their situation is. But before you even apply for the postgrad work permit, get proper advice on how you might qualify for permanent residence if that is your ultimate goal.
Consultation. How does freelance work in regards to postgraduate work permit and the PR? How does that count?
So we did a whole session last time, and I think they're recorded, right? So they should be on the Bond website on entrepreneurs and what you need to do as entrepreneurs. You might want to take a look at that and see, but your postgrad work permit allows you to do whatever you want for work, including freelance work. But freelance work very well, it doesn't qualify as self-employed work, doesn't qualify as work experience for express entry. There are other ways that may work for you for permanent residence, but come for a consult and we can figure out what would work for you.
Right. And that is a good reminder, everyone. If you go to Devant's YouTube, there's all the recorded sessions. So click on the immigration Q&A and check those out for more information, in addition to the consultation. Jude asked.
Oh, and just wanted to remind everyone, we're just looking through the Q&As right now. So if you have a question, put it through the Q&A instead of the chat.
Absolutely. Jude asks, I'm in my first semester as a student in a college in Ontario. I just got my SOWP for my wife, who will be coming to Canada soon. My study permit will expire by the end of July, but I wanted to take another course to have +1 to first extend my study permit and also get the 3 years postgraduate work permit. Question is, will my wife's SOWP visa be extended when I apply for extension?
Yeah, so there is a exception for the spousal open work permits. For those who already have spousal open work permits, I think they can extend their work permits. I'll have to double check whether or not it applies if you have you're extending for another program. I'll have to double check on that, but yeah, let me get back to you on that. Send me an email on that and I'll get back to you on that. But I know that one of the exceptions to the rule normally is if you're on your spouse and you have a spousal work permit, you can extend your spousal work permit.
Okay. Anonymous writes, I just secured a full-time job ahead of my graduation in April. The offer letter states that I need to provide proof of eligibility to work in Canada. Please confirm that I can provide my 1-year postgraduate work application submission as proof of being legally permissible to work. Is that proof?
Yes. So when you submit your application online, most of the time you will get what's called a work permit extension letter, WPEXT. Okay, and on that, it'll state specifically that you're able to work. That is great to provide to employers, and you can also use that sometimes to apply for OHIP as well. Mm-hmm. The problem with this letter is that it has a big glaring sort of misstatement on the letter in that it says you can continue to work until this date or until a decision is made, whichever comes first. And it makes it seem like if you don't have your decision yet beyond this date, that you can't work anymore. This is absolutely wrong. In fact, it says on the IRCC website that you can continue to work even beyond this date if you haven't had a decision. But it's, when an employer sees this letter, sometimes they go by what one naturally assumes is the case from this letter. I've recorded a video on our social media, which explains this part of the letter. If you wanted to go to that, watch it, or send it to your employers, you can take a look.
Is there a specific social media account or is it all?
Yeah, the social media accounts are in here. So if you search Long Mangalji LLP or if you go to Facebook, they're all on there. Any of the channels there.
Okay. They're all in all of those 4 noted. Okay, thank you.
We also have a YouTube channel as well. I forgot to put that on there. Yeah.
Yes. Anonymous writes, in several job adverts, there's a question about whether I will require sponsorship for employment, visa status now or in the future. Hey, we just talked about sponsorship.
Yeah.
Should my response be yes or no?
So, that's, again, something that is very American as well. And I don't necessarily know how to respond right now, based on your situation. But I would say you can say no if you have a post-grad work permit, but I would also be very honest with your employer when you are being hired as to what exactly your employment situation is, your immigration situation is, especially if we don't know what the points are going to be for express entry in a year or two. You may need their help. Who knows, right? And so, first of all, employment sponsorship is not a real term in Canadian immigration law anyway. Yeah.
Okay. I'm looking to work in film and television. Would this be exempted from the LMIA due to Canadian interests, significant benefits?
Mm-hmm. Yeah, we covered that in the last session for self-employed people and artists. And, there is something for the significant benefit for artists that we may be able to use for certain kinds of work. Some of them we may need to do LMIA, some of them, and there are, recruitment exemptions for people in film, etc. Come for a consultation and we'll see whether or not which way would be best for you to apply for work.
And remember, say that you're from Devant.
Yes.
Another person writes, is IMP eligible for, I guess,
Filipinos.
is
There are, yeah, there aren't any free trade agreements right now with the Philippines for either the IEC or the free trade agreement professionals category. So no, not right now.
Yeah. If I have an 8-month to 1-year postgraduate work permit, by when should I apply for my work permit? Yes, you kind of went through the timelines. If I meet the requirements for PR by then, should I apply for both?
Right. So, one of the questions that people often ask me, so when should I apply for the work permit? The question is not necessarily when should you apply, is whether you can qualify for a work permit. Okay. And that is the main question, because after your postgrad work permit, you think that it's so easy, right? Oh, I graduated and I applied and I get it. Fantastic. But that is the one thing about the post, it's a golden ticket. It allows you to work anywhere you want. No other work permit is that simple. Okay, especially employer-specific work permits. And you only get one postgrad work permit in your life. So we need to take a look. If you already only have the 1-year postgrad work permit, we'll need to take a look at your options as to whether you can apply to extend your work permit another way, whether you can qualify for permanent residence.
One of the persons asked, if they ask for a consult, is it possible to speak with you directly, Elizabeth? Because
yeah, you can send me a note. Sometimes we have 4 lawyers at our firm. And I work with a lot of employers and other people work with a lot of students. So we'll find the right lawyer to speak with you about your options.
okay. How does the postgraduate work permit work if I have a spouse with work permit? Can she continue working while I wait for my postgraduate work permit?
So your spouse's work permit is valid until it expires. Even if you had to stop studying, you've stopped studying and your student status expires, your spouse can continue to work. Now, if you have your postgrad work permit, your spouse can extend their work permit, but they can only extend it if you have a job offer. If you don't have a job offer, they're not entitled to extend their work permit based on your postgrad work permit. Oftentimes, it's a catch-22. You can't really start working until you've submitted your postgrad work permit. So therefore, how do you have a job offer, right? Sometimes we don't apply for both people together. Like I said, your spouse's work permit is valid until it expires. So let's say you have a study permit until let's say end of August, okay? And your spouse has their work permit, therefore, until the end of August. But you finish your program in April and you apply for your postgrad work permit right away, okay? Let's say you apply for May 1st. You want to be able to start working right away. Or if you don't have a job offer yet, you may want to wait a little bit until you actually get a job offer, and you apply. Or, you have to apply within 90 days. So you apply beginning of August, and which is 90 days, and you submit your postgrad work permit. If you don't find a job yet, you can wait a little bit to submit your spouse's work permit extension. Maybe until the end of the month. Certainly you want to apply before that expires. And sometimes even if you don't have a job offer yet, but later on you do get a job offer before an officer gets to your wife's work permit extension application, you can, post update for your application and say, hey, now I have a job offer. Now she qualifies for a spousal work permit. As long as you get that into the officer before they get to the application, they would still approve your spouse's work permit.
Mhm. Wow, all that different timelines.
Yeah.
If I have a postgraduate work permit, what are the steps that should be taken to get points for PR? Maybe a consultation for this one?
Yeah, definitely. There's a lot of things that go into that. Yeah. And
I mean,
take a look at some of the previous ones we've talked about, express entry and how you might be able to get more points for express entry.
Yeah, review those ones. That's a great tip. I'm an international student graduating this April, and my graduation letter will only arrive by mid-May. I had done a co-op with a company, and they're willing to hire me, but they want to know when I can start working, as they can't wait too long. What can I tell them?
Okay, so there are certain things that you can do to continue to work with them. First of all, after you finish your co-op, you can work with them based on your your study permit, right? Student status. Until the end of April, you can certainly work with them full-time. If you're a full-time student, afterwards, after you've completed your program, you can start working for them immediately right after you've submitted your application for the postgrad work permit. You don't need to have that postgrad work permit in hand for you to be authorized to work full-time. As long as you submit your postgrad work permit properly within that timeline of 90 days or when your study permit is still valid. Okay.
Okay. Are you able to provide advice for other provinces aside from Ontario if they go for a consult?
Yes, absolutely. We do every province other than Quebec. The poor people who want to stay in Quebec right now, my colleagues in Quebec are very depressed because you're not really able to apply for permanent residence if you don't speak French. And even if you do, the processing times are much, much longer than the rest of Canada. But every province other than Quebec, we certainly can assist you with that.
Okay, great. How the location works in my favor, is it the same thing if I work and live in Fort St. John or Kamloops in terms of PR? So I guess, does it matter where I lived when I apply for my PR?
Yeah, there are certain kinds of applications that are location specific. There's certain kinds of applications that are not. So Express Entry, for example, is federal program. It's applicable to wherever you want to live in Canada other than Quebec. Okay, if you want to live in Quebec, you cannot apply for Express Entry. Then there are provincial nominee programs. So it'll depend on the province, and so depending on if you're in Kamloops, for example, then you would look at the BC PNPs. And a lot of the provincial nominee programs, they might also favor people who have job offers in locations that are outside of the big cities. Especially, Greater Toronto area, Greater Vancouver area, etc. Okay. Then we have the RNIP program, which is for rural and northern, a lot of the cities, not a lot of the northern cities in Ontario, some in BC, some out in Manitoba, I think Manitoba as well. And then there's the AIP, the Atlantic Immigrant Programs, and they're for people in the Atlantic provinces. And the federal government has announced that they want to start a rural immigrant program where they'll allow you to get permanent residence if you are in other rural communities. That being said, almost all of these location-based programs are dependent not only of you being physically present in that location, but almost all of them require you to have job offers in that location. So it's no good in saying, okay, well, I'm just going to go and move out to Newfoundland, for example, because they have Atlantic Immigrant Program. If you don't have a job there, then that also doesn't work. So before you go and move anywhere, make sure you understand what programs are available and what the conditions are for them. Because it may very well could be that if you have a job offer there, you can immigrate easier. But if you already have a job offer in Toronto and, you just need to know which way works for you.
Just a follow-up, out of my own curiosity, if you got accepted into that particular province, are you obligated to stay in that province?
Yeah, so provincial nominee programs, ARNA program, etc. All of these kind of programs want to see that you intend to stay there. And so the intention is proven by you being there until you receive your permanent residence. After you have your permanent residence, you could move away, your intentions can change, and they can't really do much about it. But certainly until you get your permanent residence, if you move outside of the area, and a lot of them are employer-based, so even if you still stayed in that area, but you changed jobs, then your application would be denied. So yeah, that's something to keep in mind as well.
Please, are you eligible for a permanent job when you are on postgraduate work permit?
Certainly, you can get a permanent job means that there's an indefinite end date. And a lot of times permanent jobs are required for different kinds of programs. But whether or not you can stay with them, well, that depends on your own status.
Okay. 3 minutes left. Maybe we have one more question that we can answer. And those who haven't gotten their questions answered, please make sure you reach out to Elizabeth there in front of you. Follow her on social media, and you can see the telephone and email. Last question. I will be finishing my college in the next 4 months. I'm looking for cybersecurity analyst positions. What are my ways to get into a permanent resident ASAP, keeping in mind the STEM program?
Right. So the STEM program is a special category-based draw for express entry, and cybersecurity is one of those occupations that are certainly important for that. First of all, you need to make sure that you can actually get into the pool, and the STEM draws have points that are quite high as well. Not just, I think a lot of them are at the 480s as well. So you need to see if you can get those. But it also, there's, for STEM occupations, especially cybersecurity, there's all sorts of options. For example, if you're in Ontario or you indicate that you want to live in Ontario, Ontario has special draws under the HCP program, the Human Capital Program, where they see who is in the pool and they will invite people at a certain point level, maybe 470s or so, to apply with them for 600 points to be added to your express entry. There is also the Global Talent Stream, where employers can apply for LMIAs without recruiting if you are a cybersecurity specialist. So I certainly think that it is a very good occupation, but come to me and we can certainly talk about the best ways that you may be able to get your permanent residence.
Great. Thank you very much, Elizabeth. Thank you everyone for attending. Please note that everyone will get a link to the session. It is recorded, so you can use us as reference, and also go back to the other YouTube videos and watch Elizabeth and all her other sessions. Thanks again, Elizabeth, as always. Have a lovely evening. Have a lovely evening, everyone in the audience. Take care.
Take care, everyone.